to avoid probate. They didn't use a revocable living trust or other trust planning. They just used the will, right? If they would have used some type of trust planning, they could have completely avoided that. One of the things that I love most about trust planning is this aspect of privacy. But one of the things to keep in mind about trust privacy is that all states have different laws around this, and not all states are created equal. Some provide extreme privacy, others don't provide any privacy or really protection of the family and the details of their assets and their family dynamic and what could come out into the public eye. So I think it's worth talking about. So first, kind of the simplest aspect of trust planning and its benefit of privacy is that a revocable living trust or even an irrevocable trust will allow you to avoid probate. So probate is that legal process you go through, your assets go through once you pass away, and you have to submit inventories. And if you have a will, you submit the will. If you don't have a will, you still have to submit information about the person who passed away, their family. And so details regarding assets and family come out into the public eye. Anyone can go over that information. So a lot of times when we see that someone who's passed that was famous, a celebrity, we see that they had a net worth of $500 million or $250 million, or they left everything to this person or that person. It's because they did not do their planning to avoid probate. They didn't use a revocable living trust or other trust planning. They just used the will, right? If they would have used some type of trust planning, they could have completely avoided that. The other thing to keep in mind is in most states, there's laws that say that the beneficiary of a trust has to be notified of that trust and of what their benefit is once they hit a certain age. Sometimes it's 18, maybe it's 21, it could be 25. Point is, the state decides how that will be dictated. There are some states, South Dakota being the best when it comes to this, that have what's called quiet trust laws that that allow the person setting up the trust to completely eliminate the beneficiary from having any details regarding the trust, which could come into play could be really important, I should say, depending on the family dynamic and what your children are like. So that's something that people really, really enjoy. And then lastly, the thing that a lot of the trust planning will really hone in on related to privacy is if there's some type of lawsuit related to the trust. Maybe there's a dispute within the family about the trust, or maybe it's even that the trust is sued, maybe by a third party, whatever it may be. Some states like South Dakota, Nevada, Delaware, others say that there's certain limitations on information regarding that trust that will be subject to the public eye. South Dakota, there's a complete seal on it, so no information regarding some type of judicial proceeding is going to allow those trust details to come out. So there's a lot of different things to keep in mind when it comes to privacy. Not all states are the same, but it's worth thinking through whether you have a modest estate or whether you have a significant estate. Privacy really could be one of your best friends and should be considered with your trust planning.